Good to have you back on Newsday. 6 people have died and 15 others are trapped after a mine shaft collapsed in Zimbabwe. Collapse of Bay Horse Gold Mine in Chegutu, that's 100 kilometers west of the capital Harare, on Friday morning left more than 30 people trapped. 13 miners are said to have escaped or been rescued. Efforts to reach those who remain underground are ongoing. It is not known what caused the collapse. The Zimbabwe Miners Federation said its Secretary General and Chegutu Miners Association chairman would go to the site to try to establish what happened. Mining accidents in Zimbabwe, which sits on vast reserves of gold, platinum and diamonds, are not uncommon. Mining methods are often rudimentary and safety standards are largely disregarded.
The Supreme Court has told a former senator from Kogi State, Smart Adeyemi, that his appeal against the judgment of the 2 lower courts on the All Progressive Congress primary, which produced Usman Ododo as the party's flag bearer for November's governorship election in the state, is incompetent. Senator Adeyemi's suit against the outcome of the exercise was dismissed by both the Federal High Court and the Court of Appeal for lacking in merit. Joining us to revisit this decision of the Apex Court in the land is the Rise News analyst, Dr. Sam Amadi. Dr. Sam Amadi, what do you make of this particular decision by the Apex Court to actually strike out Sam Adeyemi's suit?
Well, I think the Supreme Court or even other lower courts like Court of Appeal have the powers and ought to be in charge of their proceedings. So first, this is a matter that came from the tribunal, from the High Court, and then got to the Court of Appeal. And the decisions of both courts were unanimous. And usually, if the whole panel of Court of Appeal affirms a decision of the High Court, it means that that decision most likely rests on strong legal grounds. And to upset a decision of both High Court and the Court of Appeal, especially where the judges unanimously agree, it will be an uphill task. You have to really show that the 2 courts misdirected themselves in law or in fact, and the threshold becomes higher for you. So that's some of the issues. And again, the Supreme Court reasoning to the fact that, look, if you allege manipulation that borders on criminal liability, the usual civil procedural rules is that although you normally win your case on preponderance of evidence, but whenever you allege a crime, the court's holding is that you should show proof beyond reasonable doubt. Proof beyond any reasonable doubt. They give you a criminal standard of proof because the allegation involves commission of crime. But again, as a legal scholar, I could say that it seems to me that maybe it's now time to review that principle of evidential law that says if somebody alleges a crime, then the proof moves from balance of probability to beyond reasonable doubt. And why is this so? Because when you allege manipulation of results, you're not necessarily proceeding against somebody to get the person convicted. So it's true that it involves some crime, but that proceeding is not a criminal proceeding. And therefore, the level of proof should not be the level of proof required to convict somebody, because that's a proof to cause somebody a forfeiture or a deprivation. The proof at the level of allegation of manipulated result is proof to show that maybe that result ought to be nullified or not taken as approved. So I would argue from a critique of that jurisprudence that maybe it's right for courts to lower the level of proof they need when a crime is alleged, but not with a way to find somebody guilty of a crime, but a way of showing that the process is not appropriate, a process didn't measure up to standard and therefore reversible. So I would argue that maybe it's time now to review those standards, because we're dealing with election, and the primary thing about election is not that somebody should be convicted for a mistake, but that the court should hold that based on those procedures, we cannot say that the ballot is credible, free and fair, whether for primaries or for general election. So I've been saying that Nigerian electoral jurisprudence needs a review. The idea of electoral jurisprudence is to protect the rights of people as citizens in general election or party members in primaries to elect their candidates or to elect their leaders. So the measure, therefore, is if you show that that process was mad, if you show that the voting is no longer credible, then the court can intervene to reverse and order a re-election. The other issue in this matter is that it looks like the relief being sought for is now academic, nugatory. Why? Because the Electoral Act provides for a time window wherein which you have to complete everything, including the primaries completed, the elections is not set. So maybe the court also reasons that if you are now alleging that the primary was false, or was falsified or not regular, and you're not asking to be declared the winner, but to redo the primary, then it looks like impossible to execute, because even if the court says, yes, that primary did not hold well and therefore needs to be redone, there's no window for practical implementation, because there can be no primary. Either the party is nullified, no candidate for the party. And so maybe the court will also say, why issue a relief that will be almost nugatory, will be basically academic, as they say. But again, somebody can argue that if the court feels that the procedure was improper, maybe the court could say so and still say, but we are constrained, we cannot nullify or declare something because it can't be done. So these are some of the issues. But I think the Supreme Court was a strong point to say, look, maybe the evidence, it didn't show the manipulation. Shouldn't be taken to the level of a criminal proof, because the indictment is not to jail, convict anybody, but to show that the process was irregular, even though it involved allegation of manipulation.
Very good, Dr. Amadi. And to add to that, the Supreme Court also hinted that Senator Adeyemi's case was more or less dead on arrival, which begs the question, why did Senator Adeyemi's lawyers go to the Supreme Court with a very slim chance, or none at all, to have their prayers answered?
Well, two factors. One, oftentimes, the normal business situation. I mean, a client approaches them and they feel like, well, this is a brief I can take. And then you try to do your utmost. The professional lawyers, the legal professional rule says a lawyer should not reject brief that within their competence. And a lawyer should give every brief his utmost best. So a lawyer can reckon that maybe, even though it looks like settled, but maybe we can move the court to see new reasons and override itself. Several times at the Supreme Court is a policy court. They can actually decide to look back and say, these established precedents or established principles of law seem to be deficient, and they can use a case to make a new law. That's how the Supreme Court makes law. They can look back and say, well, in circumstances like X, Y, Z, then the law could be, the principle should be this and not that. So many lawyers will reason that maybe we will be able to move the Supreme Court to nullify itself, to overrule itself, or to create a deviation or some exception to the rules because of deserving circumstance. But again, the idea is also the idea of lottery. We just go there, we lose nothing. If we don't contest it, we are out of the game. So why don't we throw our dice in a fall somewhere, we lose, it doesn't matter. We win, we gain. And that's really what courts don't like. And that's why oftentimes they penalize lawyers when such litigation is vexatious and outrightly unreasonable. And so the court uses its power of sanction to control entry into the judicial process. Because again, the court is busy. The court has full docket, and the court must exercise disciplinary actions to restrain narrow the aperture of entry into their terrain. Again, in the U.S. Supreme Court procedures, they can't go to the Supreme Court. They sit to first certify cases they will take. But because of the way our election cases come, in staccato manner, not programmed, it will be different for the Supreme Court. But in the U.S., they do that. And so when they certify what they will hear, and your case didn't make it, you know that the Supreme Court House, in chamber, preliminary, discountenance your argument and say this case does not provide any possibility of even wasting our time to consider. So I've always written and argued that the Supreme Court should exercise more preliminary powers to sort out cases they hear. Otherwise, and the way we have interpreted right to hearing in Nigerian jurisprudence, almost like guarantee everybody the right to be in the Supreme Court. So we say you can take matter on appeal, provided there are tribal issues of law, provided there is a question for determination, constitutional question for determination. So they create a fait accompli. They kind of bind the Supreme Court or the Court of Appeal to take a suit. And then in their hearing, they will not say this is nonsense. Sometimes they attack the lawyer, they criticize the lawyer and sanction the lawyer. But the notion that we have a right to hearing and that right compels the court to hear you is one I think needs to be modified. Right to hear is critical, but at the same time, the judicial attention and judicial process is a wastable resource. And so it has to be conserved. The time, the process, the procedures. So the Supreme Court takes all the time to hear frivolous matters. Then they might not give the level of attention that they need to deal with real issues that they need to probably provide more attention. So I think that's a cost to this liberality. If the Supreme Court allows everything, the Supreme Court has 24 hours like every other institution. It has limited bandwidth of time and attention. Then if it gives everybody a right to entry, then it's going to underserve critical areas that it needs to research more or pay more attention. So I think there should be a balance here, and the court should be more proactive to sort out and reject arguments that are clearly frivolous and it considers not justiciable or not something that he wants to take up. And I think that's what we should see. So I agree with you that lawyers have incentive to take cases up, especially those who are not senior advocates, by the way. Those who are not senior advocates have additional incentive to go upstairs because the way we define senior advocate merit procedure or criteria is based on quantity, not quality. And so one has to get 3 senior advocate Supreme Court decisions either way, whether it's a useless decision, whether you failed or you lost, it doesn't count. Get decisions. You then need to, within a space of period. So you want to take every case you have to Supreme Court because you're not even thinking about the quality or how you shape the law. You're thinking about getting 3 Supreme Court cases or 6 Supreme Court cases in a period of 3 or 5 years so that you can become a silk. These are some of the perverse incentives that influence why cases get to the Supreme Court, which ought not to be there in the first place. All
right, Dr. Amadi, as we try to wrap up this particular discussion, you mentioned something about electoral jurisprudence because a lot of people have looked at decisions emanating from tribunal and a lot of people have noticed lapses, they've noticed lacunas. A lot of people have noticed inconsistencies. We've seen things happen. Case in point, what is the decision from the tribunal in Kaduna State and several others has left people more confused than ever before. And it almost threatens the morality and also the sincerity of the process if they are not sure what to get from the tribunal.
Absolutely.
Briefly, if you can help us appraise the tribunal judgments in several cases from the state level so far, and what can be done to ensure that we get more people-focused decisions as against technicalities and what have you.
Absolutely correct. Absolutely. So the problem is this: lawyers and the legislature have connived or worked together to create a mess, a confusing mess of technicalities that leaves the judges themselves and the messy victims and trapped. See, most of the technical rules, sui generis, the tribunal cases must be this nature, that nature, should be discarded. Judging should be a craft based on latitudes of taking evidence and considering them and then deciding on what looks more to them like legal justice. So I think the rules are too constraining And that's why the rules can mix direct many judges. So you see some judge take this rule, this one takes a different rule, and then they confuse. Outcomes are not standardized. So first, I think we should dismantle the very complex and confused and incoherent, actually, because they're made from different times. People don't consider them well. They just make this rule, make that rule. Too many technical rules should be dismantled. Let electoral justice be like any other form of litigation, where judges are in control, judges appraise evidence, make up their mind, and say this is the way we go. That's number one. Number two, I think there's need to clarify that the essence of electoral petition is not to deviate from the will of the people. Litigations in elections are not opportunity for judges to decide who should be governor or senator or president. It's for judges to try and decipher, find out what choices the people made. And where those choices are not clear to be found, because the procedure itself is substandard, the judges can truncate the procedure and ask for a repeat. It's not their job to pick winners, to sit and then use confusing technicalities to pick winners far from the people's expression. So take, for example, the Kaduna case. Again, different interpretations. So the judges can say that, okay, you should have filed this between... I think it doesn't make sense for the merit of a case to be decided on the basis of a lapse of time within which to file something. If it was filed, the judges should reject it before judgment. If they accept it, they should exercise their jurisdiction to receive it and consider it. The notion of front-loading all documents, creating expectation, and then during judgment, you have taken time to hear everybody. After judgment, it says this is incompetent because it was filed out of time. I think they need to review that. Jurisprudence of elections is to get the voters to choose, not cost to choose.
Indeed. And on that note, Dr. Sam Amadi, a Rise News analyst, I'd like to thank you for your perspective on those issues. Good to have you with us.